Yes, happy Monday, happy National Championship Day, as Melissa kindly reminded me.
Okay.
She was like, you do know that the game starts at 7. And I'm like, what game? Oh, that game. Okay.
Not what game?
The SEC National Championship. I think that's what it is. I don't know. Oh, hold on. I always forget that Instagram can see all of me and not just my top half. So, hey, Matrice, you get to see all of me in my Captain, what are these? These Avenger pants that I have on. Yeah, you get to see all of it. So, hey, beautiful people, how y'all doing this Monday? Hey, Jacqueline. Let me invite Jacqueline up. Let's see. There we go. Let's see. What am I looking for? Nothing. I think I have everything that I need.
Hey.
Cool. Man, we got some good questions today. And I am planning to keep this to about 30 minutes so that we can go on about our day. But it's going to be a great 30 minutes as soon as I find my questions. So we start in about 1 minute. So we will get started. Let's see, I'm live here. I'm live there. And we'll get started in exactly 1 minute. I mean, goodness gracious. She says she knows, but if she comes in here one more time, she's like, don't fuss at me. I know. But she keeps running in and out of here, making all the noise. All of the noise. Hey. So, welcome to Murray's Law. So anybody that is new to my platform, whether you're on Clubhouse, Instagram, or YouTube, welcome to Murray's Law. Let me tell you a little bit about it. So Murray's Law is our weekly Q&A where we answer your questions about trademarks, copyright, business, right? All the things that you as an entrepreneur want to know, you need to know in order to run a better business. So you can stop writing dirty in your business. At least you'll know how to stop writing dirty and what constitutes writing dirty in your business. And so for those of you who don't know what I'm talking about, that means, like, you know, if you've ever driven in a car and maybe your license was suspended or maybe you didn't have insurance, that's what we talk about, writing dirty. But on the legal side, on the business side, writing dirty looks like not using written contracts. It looks like not having your trademarks and your copyrights in place. You know, it looks like hiring people as independent contractors when they're really employees. That's what we're talking about in writing dirty. And sometimes you don't even know you're writing dirty. So that's why we have Murray's Law here. All right. Hey, Danielle. Hey, Janelle. Junel. I'm sorry, I pronounced your name right. Hey. Thank you so much for joining us. So with Murray's Law, what we do is we take questions from the Genius Insider first. Our Genius Insider is our legal and business membership program. That is our paid subscription program where you have access to an attorney. You have an attorney on your team for free consultations, document review. And because I understand that when you're starting a business, you need not just legal, but also business help, we also have master classes that encompass both business and legal. What? For one price, one low monthly price. So that's the Genius Insiders. If you are a member, your questions are answered first. If you are in the Genius Lounge, which is our free community, your questions are answered second. So if you want to join the Genius Lounge to make sure your questions get answered, go ahead and do that. It's geniuslounge.co. For those of you who are new and don't know who I am attorney LaConya Murray, brand attorney and owner of Off the Mark IP Solutions, and I help clients throughout the United States protect their brand and own their genius through trademarks, copyright, and business development. Listen, we're not going to go through a whole long who am I. We're going to go ahead and jump into these questions. How about that? And this is not it. Ha. I thought I had the right questions up, but I did not. What is today? Nobody can tell me what today is. Okay. The first question is a really good question. And that question is, this person says, I have a t-shirt company that I do business with online alone, but sales happen across the United States. Do I need to have a federal and or a state trademark? Awesome, awesome question. Do I need to have a federal and or state trademark? So this person has a business in one state, but they operate and sell their products throughout the United States. What kind of trademark do they need? Federal or state? So let's just talk about federal and state trademarks for one moment. What a state trademark will allow you to do, so let's just talk about trademarks. So trademarks protect brand identifiers. Those are the things that help consumers readily identify the source of a good or a service. The source of a good or a service. And what it allows the owner to do is to prevent other people from using the same or similar mark in that same or related field. So in this case, this person sells clothing, right? So if someone had his same mark, he would be able to say, hey, I have this state trademark. No one else in whatever state he's in will be able to use that similar mark as him. But a state trademark is limited to just that, the state. And most of the time you go through your Secretary of State website in order to get it done. On the other hand, a federal trademark, so trademarks, whether state or federal, are going to protect brand identifiers. However, the state protection is limited to on the state level, but the federal protection is going to allow you to prevent people throughout the United States from using that mark, right, in that same or related field. So if you have a business where you're doing business, selling services throughout the United States, there's no need to get a state trademark because your federal trademark will protect you in all of the United States. So that is a good question. That is a good question. So the next question. Let's see. The next question is, is it better to register the business as an LLC before filing for a trademark? I like this question. I like this question because, one, it lets you know that, hey, there is a difference between an LLC and a trademark. A lot of people think that when they register their business with the state, that now their name is protected because they were able to get it with the state. When you get that LLC, that's just so the states to know who has a business in their state, who they need to be collecting money from. It has nothing to do with a trademark. There are a lot of businesses that have their business name registered with the state, but the name that consumers identify with them is different. So because sometimes they use an assumed name or what we call a trade name or doing business as, like a DBA. So that is the trade name is the trademark. So just because you're able to get that name registered in the state doesn't necessarily mean that you have a trademark. It just means the state know that you have a business. So if you want to know whether or not you should get an LLC or a trademark, which one you can do first, it just depends on where you are in your business. And this kind of ties into another question we have, which is whether or not you should wait until you make your first sale until you get an LLC. And the reason that it ties in together is because, listen, that LLC, what the whole purpose of it is to make sure that your business liabilities do not touch your personal assets. You want to keep your business and your personal separate. That's why you get an LLC. That's what that limited liability comes into, because your liability is limited to your business and it doesn't touch your personal. As long, see, you on Clubhouse can't see my face, but you on Instagram and you on YouTube, you can see my face. So as long as you run your business separately, stop filing for these LLCs, right? Because you can go online and fill out the paperwork in like 10 minutes. Stop filing for these LLCs and then not doing the other things you need to do to make sure that you get your protection, because the paperwork alone is not going to cut it out. It's not going to cut it. If you're going to ask the state to see you as separate from your business, see your personal assets separate from your business liability, you got to keep them separate. You got to keep them separate. You got to open up your separate business accounts. You got to have your separate phone numbers. You got to have your policies in place. That's what, when people talk about boundaries and stuff, when you actually set business boundaries, now you're setting it up so people can say, oh, I contacted her during business hours on her business line to conduct business. So if something goes wrong, they can't sue you. Or if they do sue you, they can't say, well, I didn't know she was a business. I just thought she was operating as herself. Because notice is one of the things that you have to do when you have an LLC. You have to put them on notice that they're doing business with someone that has limited liability. So if you're going to ask for someone to see you separate, if you're going to form this LLC with the state, please do your part and run your business and your personal separate. Okay, coming down. And so, when it comes to whether or not you should file your LLC before your trademark, or if you even have to wait until you get your first sale before you get this LLC, this is this. The point is this. Are you getting ready to put yourself in a position where you're going to be liable for something? Are you signing contracts? Are you selling products or providing services? Something that you want to make sure that you're protected on, right? If you're still in that, a lot of people, because you don't go from business idea to fruition like at a snap. Like you don't think of the idea and then all of a sudden it's there, right? You don't do that. So for some people, you have this idea for a business and then you start the business plan and you start getting things like lined up. Maybe you haven't signed any agreements yet, but you're starting to get things lined up. So if that's the case, especially depending on how unique your mark is, how unique your trademark is, you might want to go ahead and get that trademark protected since you're not doing any business with the LLC. Like you're not entering into any agreements or contracts with the LLC, right? So if you have to, you can get that trademark first. You can get that trademark first to make sure that it's protected. You can get it in your name, or if you have a partnership, you can get it in your name and your partner's name. And then once the LLC is formed, you can transfer those assets to the LLC. So that's what you can do. So it's not a do I have to get my LLC first. You can. You absolutely can. And if you're in a position where you can get the LLC before the trademark, then go ahead. But don't let you not having an LLC prevent you from protecting your brand. Okay. So, good questions. Let's see. Where we at? And I can't even see what's going on YouTube. Okay, there we go. Then the other question is, which is more important as a business filing for your taxes? So I'm assuming they want to know whether an LLC or a trademark is more important as a business filing. And I'm just going to tell you that taxes are outside of my realm of genius, but I do want to let you know this. If you're an LLC and you're a single member LLC, let me just put it this way. Trademarks have nothing to do with your taxes, like as far as your tax filing. So I guess you would say your LLC, but depending on how you elect to be taxed as an LLC, you're probably going to be taxed as a single member anyway, which it would be just like if you didn't have an LLC. So talk to your accountant about your business model and your income expectations, because once you hit a certain threshold, like a certain income amount, you do not want to be taxed as an LLC, not as a single member LLC. Trust me, baby. Trust me, as someone who has seen 5-figure tax bills, you do not want to be taxed in that way. You want to be, when you get to a certain level, you want to go ahead and elect to be taxed as an S Corp. But again, you talk to your accountant about that. Good questions. So so those were 3 questions. Then we went ahead and answered the question about should I wait until I make my first sale to form my LLC? And I'll be honest with you, that question came from just, these stimulus checks were coming out and everybody making big plans for how to spend other people's money, right? Telling them what to do, what not to do with their money. And one of the things that was floating around is take that money, but get an LLC, commit some tax fraud by, applying for these loans, blah, 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 blah. Not doing that. And then other stuff was saying, well, don't rush out to get an LLC. You need to wait till you make your first sale before you get your LLC. There is no blanket way, there's no blanket advice. There's no blanket way that you should be doing things. It really depends on your situation, what you're doing, what your goals are, and where you are, right? You don't have to wait until you get your first sale. If you wait until you get your first sale, that means the person that's getting that sale, they're not contracting with your you as an LLC. They're contracting with you as an individual. So let's say you sell them something, right? Say you sell them a coaching package, right? As an individual. And then they come back and say, well, your coaching package didn't work for me. Because it didn't work for me, I was out of X amount of dollars. And this amount of money was more than what I paid because I expected to do this and blah, 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 blah. So now they want to sue you, right? Instead of suing you as your business, they're suing you as an individual because that's who they ended the contract with. Because you waited until you made your first sale to get your LLC. So no, we're not doing that. I mean, some people do it, and I understand some people, because sometimes, I mean, it's not hard to get into business. Like, literally, you start selling and providing good or service for profit, you in business, right? So, I see how some people can end up in sole proprietorships or partnerships, like, real quick before they have a chance to form, get their LLC formed. But if you have the opportunity, now that we're slowing down and thinking about it, right? Now we're slowing down and planning it out. Now that you have this opportunity, hold on. Here we go. Now that you have this opportunity, you want to, if you can, get that LLC. And I'll put this caveat out here, if that is the right business formation for you. Stop getting an LLC because you see everybody on the internet getting an LLC. Talk to your lawyer, talk to your accountant, and see if an LLC is right for you. Okay. Cool beans. Okay, so that is that question. And I will tell you this. There are a lot of people, a lot of these questions have to do like, when do I do something? And a lot of times I always tell people, what does your business plan say? Where are you at in your plan? That will dictate what you need to do. And oftentimes people don't have a business plan. If that's you, if you don't have a business plan, or if you really want to have like the legal basic foundation, like I have resources. I have the Legal Basics Handbook and I have the Business Plan Workbook. I have both those resources available in the Genius Lounge. And what I'll do for you guys, since you're on here rocking with me live on Clubhouse and trying to help me get over my nerves a little bit, I will give you a coupon code. And it's good for if you're watching live on YouTube and Instagram, you can use the coupon code as well to get $5 off the Business Plan Workbook or the digital plan bundle, which is the handbook and the workbook. So there you go. I think that'll make the workbook like $25 or $30. But there you go. Felasha Day, hey boo. I'm sorry, my bad. But hey, that is the accountability accountant. So we're sitting here and she'll tell you about LLCs and taxes and making sure, like, that's not for everyone. It depends on what kind of business you have and what kind of money you're looking at. Depends on how you want to be taxed. So there she is. Okay. So next question is, I have a trademark for my brand. Do we also need a copyright to protect the material, or is it automatically protected once the trademark has been accepted? Another good question. Look at y'all coming through with these questions. I love it. So, again, I'll tell you. So, the question is this. I have a trademark for my brand, but that brand is relating to, let's just say, a course, because, a course, right? Do I also need to get a copyright for the course, or is the course protected by the trademark? Okay. So, trademarks protect the brand identifier, which is the source of the course, right? The thing that identifies the source of the course, that's what a trademark is going to protect. The course itself is an original work that's in a fixed tangible form. And because it's in a fixed tangible form, it's protected by copyrights. Those are both forms of intellectual property, but they're two different forms of intellectual property. So your trademark is going to protect that brand identifier, and your copyright is going to protect the content. So you will need both. I need the trademark to protect, let's say you have, just go with Felasha Day, the accountability accountant. That is a brand, that is the trademark, that is the brand, right? But when she hosts she teaches people how to do QuickBooks. Oh my gosh, she teaches people how to hire their kids as a tax write-off. So when she hosts those courses, when she teaches that material is protected by copyrights, and we need to file a copyright to protect that material. Y'all are on fire with these questions. Fire! Oh, did I not make anybody moderators? Hold on, y'all. You know y'all got to tell me this stuff.
It was on a roll. We was just letting you get it.
That's what I do. I'm like, at 7 o'clock, let me get started. And so for everybody that's watching me on Instagram and watching me on YouTube, and you're like, who is that strange voice? I don't see nobody. We are also on Clubhouse, streaming live. So that's where that's coming from. So let's see what we have going on. And we're going to take questions. What I'm going to do is go through the pre-submitted questions, and then I'm going to take questions from the audience. Let's see. I think we have... Okay, so that was the last question. So basically, they want to know if we get a trademark, do we also need to copyright the material? And is there a difference between trademarks, copyrights, and patents? And we just talked about that. And yes, so trademarks protect brand identifiers. Copyrights protect work in a fixed, tangible form. Patents protect inventions and plants. You know, you got a plant patent and things but it's an invention, right? So those are all forms of intellectual property, but they all protect different things. And if you want to go even deeper into the differences between those, there's a free mini course at the Genius Lounge, right? A free mini course, Protect Your Brand Startup Guide mini course, which talks about all 4 of the intellectual properties in depth. So you can go to the geniuslounge.co and geniuslounge.co/shop. That'll take you to the shop where you can get the handbook and workbook that are on sale for $5 off, and where you can get the free mini course. So yeah, those are the questions. So basically, they want to know if I get a trademark, will it protect my course, or can someone take my materials with the name, like basically come up with their own name and then copy the content as their own? Yes and no to that question. So the trademark, yes, because the trademark only protects the brand identifier. So you're protecting whatever that brand name is. But no, because when you have a copyright, here's the thing you have to know about copyrights. Copyrights attach from the moment it becomes a fixed tangible form. It's an original work in a fixed tangible form. So when you have that fixed tangible form, that original work in a fixed tangible form, you have a copyright. The challenge is that you can't sue anyone for infringement unless you have a federally registered copyright. And if you want to get all of your, all that's coming to you, you want to make sure that you file for that registration before the infringement, or before like 3 months after you publish it. So that's why we say go ahead and get it done, because you don't want to. People act quick. Y'all know how fast people are. People see something they like and they try to copy it quick. So that's why we say go ahead and register it. All right. So that is good. Hey, listen. Do y'all have questions? And let's see. How do I get back to where I was? Here we go. No, stop. Okay. I'm just going to stop. I don't know what I'm doing. I'm sitting here on Club. Here we go. There we go. All right. So does anyone have any questions, whether you're on YouTube, whether you're on Instagram, or in Clubhouse? Do you have questions? We had some really good questions. We have about 8 minutes left before we wrap up. So we have plenty of time to answer any questions from the audience. And Falash today, she just popped out. Oh. Let's see. Here we go. If you have trademarked your company name and you are offering a product or service that, listen, me and this Instagram, a product or service that you have given a unique name to, what point should you consider trademarking the product or service name? Ooh, I like that question because it's levels to it, right? You have your brand name, but then you have your product, and especially if it's something that is unique, you want to go ahead and protect it. And it also depends on how big the catalog of products and services are as well. So if you have a trademark, and Barrett, is this Barrett? Barrett, I see you in the clubhouse. I see you. We just had this conversation the other day. But yes, if you have your brand, right, you have your brand. And a prime example of this would be, prime example. So I have Off the Mark Protected. Off the Mark is our trade name that we do business under. But under that, we have a service. We provide the Genius Insider. Genius Insider is our legal business and business membership program. That is the second trademark. And then even under that, we have our online shop, which we call the Genius Lab. And so that's another trademark. Exactly. On Instagram, Barrett says McDonald's has, they have that trademark, and then Big Mac is trademark. And they're particular about what they choose to trademark. Everything is not trademarked. The Big Mac is, because that's a signature product. That's something that they're known for. But their cheeseburger, the double cheeseburger is just a double cheeseburger. So, great question. All right. Any other questions? And thank you for everyone that's watching live from Instagram, and everybody that's watching from YouTube, and everybody that is on, there we go. Everybody that is on Clubhouse. So I just invited Falasha Day up because I know she had a question. Do you still have a question, Falasha Day?
Hey, Connie. So thank you so much for inviting me to your stage. I appreciate this opportunity being one of your clients that have a pending trademark application. Guys, she is the absolute best. But I wanted to ask you one question. This ties into what you mentioned when I was in here earlier about copywriting my courses. So I know what you mentioned to us, how I have to have it present, right? As you mentioned. So now are you saying that when I relaunch my How to Hire Your Child Again masterclass, I need to come to you to get a copyright? Is that correct?
Yes. If it's not, if it's in a fixed tangible form. So if you're teaching it live, we wouldn't do it live.
You're muted.
Oh, thank you. I'm just talking. So if you're teaching it live, then we can't copyright the course until it's in a fixed tangible form. But what we can protect, if you're teaching it live, like if you have slides, if that's you're teaching off of, we can go ahead and protect that content before you present it.
Got it. Thank you.
You're welcome. Let's see. Cool beans. All right, dude. We have another question here on YouTube. Kickstart with Ann says, "Hey, LaConya, what's the contact information for the young lady you mentioned? She's talking about you, Falasha Day. So I am going to drop your information into what's the best here. Unmute yourself and tell us how to get in touch with you, because that's an awesome class."
You guys can just follow me on Instagram. It's Falasha Day, the accountant, on Instagram. Spelled F as in Frank, O-L-A, S as in Samuel, A-D-E.
Thank you. And I'll drop the link in the YouTube as well. So that is good. And I'm going to talk to you. I'm going to send you an email, so look out for it, Falasha today, because I would love for you to do a masterclass inside of the Insider.
Okay, thank you, Connie.
Listen, you don't even know this yet, but I've already put you down on the calendar. Like, I have the date and everything, so all I have to do is reach out to you and see if you're open to it and available.
I'm there.
Thank you. All right, awesome. We have 3 minutes. What other questions do you have? Danielle, hey Danielle, how you doing? Stylist to the stars, speaking into existence. Let's see. Just making sure that I'm just checking all the places. All right.
Can I ask you a question, LaConya?
Always.
So when you say fixed tangible form, you say she needs to have her content in a fixed tangible form. Mm-hmm. Do you mean just a structured form, or what do you mean by fixed tangible form?
It doesn't necessarily have to be.
What would constitute?
What would something literally that's so the big question of law is like how long is fixed? Something can be in a fixed form, right? But it doesn't have to be in that form forever. Meaning, if you have a recording and then you and then the record breaks, right? It was in a fixed form, fixed tangible form, but then it broke. So it's not in existence anymore. But that's all we mean. It's like it's something that is literally in a fixed form that can be touched, like tangible touch. So, and it doesn't have to be pretty. It doesn't have to be like pretty, but if it depends on what you're trying to protect, right? If you're trying to, so let's talk about this, especially as it relates to courses. This is something that everybody needs to know, is that when it comes to courses, people always, this is their big question here, is like, how can I prevent people from coming to my course and then taking the course and then going to teach on it? And the answer is you can't, right? If you think about it, right, we all gather our information from somewhere. We read books, we hear people talk, we take classes, we are all learning that information. The difference is we're taking it and we're processing it and we're spitting it out in our own unique way. And that own unique way is the thing that you're going to protect, right? That's what you want to protect, is that your own unique way. So whether you have a specific framework that you use, or if you have a specific, like your slides and your actual content. So what people can't do is take your presentation, copy it, like record it, and then sell it. They can't take your presentation and sell it, because that's protected by copyrights. But if you're teaching a course on QuickBooks, they can teach somebody how to do QuickBooks. That's not what you're protecting. You're protecting the way that you do it. You're protecting because you spend all that time putting the content together. You put all that time, making the presentation. That's what you're protecting. And that's why I always tell people that it's really about the brand. So you have your copyrights, you have your patents, but it's really about the brand, because people buy from people that they know, like, and trust. And if you're known to get results, it doesn't matter if someone else is teaching the exact same thing. People heard about you and they want to work with you. They want your course, whatever is branded. This question.
Thank you.
You're welcome. Thank you for the question. So the question says, as a content creator, if I put a TM behind something without actually filing for that mark, does it really protect anything? I like that question. And I like that question because we get to talk about what a TM is. So we see that all the time. We see TM, we see R with the circle on it, we see C with the circle on it. So when you see that TM, what that lets people know, it puts people on notice that you are working with a common law trademark, that is protected by common law trademark. Because trademarks, just like copyrights, once you begin to use that mark associated with a good or a service in commerce, now you have a trademark or service mark. So trademarks relate to products, service marks relate to services. So as a content creator, you will actually have an SM. But what that lets people know is that, hey, that for you, that this is a service mark or a trademark. And it deters people from using that mark. It lets them know that this is someone's intellectual property. Now, as far as it does protect some, your protection is limited. Your protection is limited to your geographical area, but it does offer some protection. But you still want to get that federal trademark. If you're doing business in commerce in multiple states, you do want to get that federal trademark sooner rather than later, because you don't want to end up costing you more money, because you have to defend, cancel other people's trademarks that might have registered before you, or the market's starting to get saturated. Like, you want to go ahead and protect your brand as soon as you have the opportunity. But In the meanwhile, yes, you can use that SM or TM to identify the source of a good or a service. Let people know that, hey, this is my intellectual property. You can mess with it if you want to, but don't. As a matter of fact, when you're going through that trademark process, you're going to use that S or TM. You won't use that R with a circle on it until it's registered. When your application is approved, you go from TM or SM to an R. It doesn't matter if you have a trademark or a service mark. When they're registered, they both have that R with the circle on it. All right. Great question. Great question. Let's see. We got time for one more, if we have any more. All right. And what else? So if there are no more questions, and I'll just keep an eye out while I tell you this. Taking that out. So remember, you have a coupon code to save $5 off the business plan workbook by going to geniuslounge.co/. Oh, I didn't give y'all the coupon code. Duh. Let me tell you what the coupon code is. In honor of the SEC National Championship that is being played right now, the coupon code is Roll Tide. So use that coupon code, you get $5 off of your handbook, off your business plan workbook. And also, the Genius Insider, we closed that over the weekend. But for you guys, if you're interested, I did open it back up, but just tonight. So we do have a few more slots available. So if you want to join the Genius Insider, do so now, because when it's closed, we're going on not only a wait list, but the next round will be application only. So you're going to have to apply. So we're looking for we want to work with certain people. We want to work with people that are ambitious. We want to work with people who are committed to building better businesses. I'm not looking to be one of those subscriptions that you purchase and then you just kind of forget about. I'm not looking to be that. I'm looking to make sure that I'm a resource for you. So I want to work with people who are working on their business. So that's why we have an application process. Let's see. Quick question says, let's see, how do I do this? This question is from Gary on YouTube. And Gary says, hey, Connie. Hey, Gary. Thank you for the great info as always. How do artists protect themselves in portraits of well-known figures? Ooh, so how do artists protect themselves? So is the artist the one doing the work? Is that what we mean by artist, the one that's actually bringing the work to life? And they're bringing to life well-known figures? You can get a copyright for that work, depending on that. So now you have this line that you're towing, right? You have you as the artist that's creating original work, but then you have the public figure who has what's called a right of publicity. They have a right to say what happens with their image and their likeness. And so it just really depends on the context of the work, as far as what your right as the artist will be. Yay, okay, great questions. I love this. So this is what I want y'all to do. Make sure you go to the geniuslounge.co. It's free. Go to geniuslounge.co, sign up so that you can see every time we go live. So that you can get notification, get the email that we're going live. Yes, we will stream to Clubhouse, Instagram, and YouTube. But if you don't know, then you miss out. And because this thing is only 30 minutes, if you don't submit your questions beforehand, you risk the chance of not getting your questions answered. And we want our questions answered, right? We want our questions answered. All right, so I'm checking. I don't see any hands that are raised. Anybody on Clubhouse have any more questions? Checking YouTube and checking Instagram. You're welcome, Gary. Cool to the beans. All right. Well, that's what I have for tonight. I'm going to sign off over here at, maybe I am. Let's see. I'm going to sign off on the YouTube. All right.